LLB honors LLB honors London degree, and she's a world prize winner at the University of London as well. So, welcome Miss Ayodya Alwis, and I'll be handovering this session to her, and she'll be conducting this session throughout. And if you guys have any sort of questions, you can always post it to me, and I'll be always posting it to our resource person, Miss Ayodya Alwis, and she'll always be willing to answer as well. So, welcome, Miss Ayodya Alwis. We are indeed honored to have you with us today to handle this session and to host this session for the premier student who are willing to and who are hoping to write their exams in April 2026. Over to you, Ayodhya Alwis.
Mabroor, you can hear me, right?
Yes, you're
Yeah,
audible. You're
okay.
audible.
Okay, right. So thank you for that lovely introduction and good evening to all of you. So first, I would like to thank Pro Studies for inviting me to do this session. If I'm to say about today's session's outline, I'm not going to do a specific lesson per se. What I'm planning to do is to give you some guidelines on how to prepare for the exam and how to do the exam, how to perform at the exam. Because I think the issue lies with, like, not with the knowledge, but with the way that you are giving your output at the exam. So, right, let's start the session then without wasting your time. Okay. And if you have any questions, you can put them into the chat box. And anyway, you will get the answers for your questions by this session anyway. But and the other thing is, I specifically outlined this in a way that it addresses most of the questions that we have when we are preparing for the exam. So I guess this will be beneficial for you all. Can you see my screen?
Yes, your screen is visible as well.
Okay, right. Okay. So today is March 21st, and I think exam starts on 23rd. So we have like 1 month, right? We are just 1 month away from the exam. And I should say that this time is more than enough for you to make a difference. Don't think about where you are standing right now. If you manage your time properly within this month, if you utilize the time in the best possible way, I can guarantee you that you can score very good marks at your exam. The only thing is, we have to work in a smart way. So, as you all know, we have 8 modules, and I'll be discussing about all 8. Discussing as in, I'm not going to discuss a specific lesson. I'll just give you some tips on how to handle that subject. So I'm not going to discuss about environmental law because I didn't do it. I did conflict of laws, so I'm not in a position to give you advices on it, uh, as I'm not like much aware about it. But I'll discuss about conflict of laws, and I'll keep it for the end because since there are some students who are not doing it. So now you are at the stage of preparation. As I said before, you have 1 month, uh, almost 1 month, yes. And the most important thing that I wanted to highlight is you have to use the law college lecture notes. Law college lecture notes, as in sometimes even the same lecturer, like some lecturers have been teaching here for several years, and you have to make sure that you are referring the most recent updated notes. And තව සිංහල medium Tamil medium එහෙම කරනවා නම් translations ගන්න ඕනේ. එතකොට ඒ translations බලන්න හරියටම අර original ඉංග්ලිෂ් නෝට් එකත් එක්ක ඒ විදිහටම තියෙනවද කියන එක. මොකද කේස් ලෝස් වැඩිපුර ස්ටඩි කරොත් අනවශ්‍ය විදිහට ටයිම් එක වේස්ට් වෙන එකයි වෙන්නේ. එතකොට අපරාධේ ඒ වෙලාව ඔයාලට කියන්නේ හරියට යුටිලයිස් කරන්න තියෙන ටයිම් එක නිකන් වේස්ට් වෙනවා අනවශ්‍ය දේවල් ස්ටඩි කරන්න කියොත්. ඒ නිසා you have to make sure that your Sinhala or Tamil translation is like it's a very good perfect translation of the original note. ඒක important point එකක්. මොකද lecturers ලා නිතරම කියන දෙයක් තමයි as an example our constitutional law lecturer Mr. Suren Jnanaraj. Suren sir always tells that not to rely on old recycled notes. In his words, he says that not to rely on old notes. ඒ හින්දා updated notes ම use කරන්න හැමතිස්සෙම. And past papers. Past papers, it's very important for you to prepare for your exams. Uh, since you are in the stage of preparation, this is a preparatory stage, make sure that you go through at least 5 past papers for each subject. ඒ කියන්නේ දැන් වාඩි වෙලා ටයිම් කරලා ආන්සර්ස් ලියන්න බැරි වෙන්න පුළුවන්. එහෙම ටයිම් එකක් නැති වෙන්න පුළුවන් because I guess some of you might be doing other degrees and some are employed and you have other personal commitments. ඒ නිසා ටයිම් එක ටිකක් හොයාගන්න අමාරු වෙන්න පුළුවන්. But at least make sure that you are going through the past papers and try to be familiar with it. එතකොට එක්සෑම් එකට ගිහාම අර නිකන් තමන් ස්ට්‍රේන්ජර් කෙනෙක් වගේ එහෙම ෆීලින් එකක් එන්නේ නැහැ. පාස් පේපර්ස් බලලා අර තමන් කියන්නේ පොයින්ට් අවුට් කරන්න පුළුවන් ද බලන්න මෙන්න මේ ටිකයි මම ඩිස්කස් කරන්නේ. ඒ ටික කරන්න කියන්නේ මෙන්ටල් නෝට් එකක් හරි තියාගන්න බලන්න. එතකොට පාස් පේපර්ස් කරන එක it's a very crucial point. And another question as in another issue is how to memorize the case laws and sections and everything. Law is very broad and it can be very bulky. It's obvious, right? We have so many subjects and even like each subject is divided into several parts, several subtopics, and there are different lecturers. And sometimes there are way of teaching might be different with all those things, and there are on top of that there are so many case laws and sections. It's hard to memorize. එතකොට අර කටපාඩම් කරොත් ටිකක් අමාරුයි කරගන්න. ඒ නිසා බලන්න ඒ කියන්නේ අර පැසිව් රීඩින් කරන්නේ නැතුව නිකම්ම පොත දිහා බලන් ඉන්නේ නැතුව ඔයාලව කියන්නේ තමන්ට එන්ගේජ් වෙන්න පුළුවන් විදිහකට ස්ටඩි කරන්න. ඒ කියන්නේ maybe you can teach someone or you can draw diagrams. ඒ වගේ මොන හරි අර තමන්ව එන්ගේජ් වෙන්න පුළුවන් විදිහේ මෙතඩ් එකක් යූස් කරන්න. ඒක like the method can be different from one person to another. එතකොට මම කරපු විදිහක් තමයි නිකන් අර රෆ් ෂීට්ස් වල ලියලා එහෙම පුරුදු වෙනවා. ඒ වගේ අර නිකන් පොත කියවන්නේ නැතිව ඒ වගේ වෙනත් මෙතඩ් එකක් යූස් කරන්න. ඒක තමන්ට යුනික් මෙතඩ් එකක් වෙන්න පුළුවන්. ඒ වගේම another important fact is studying during the gaps. So the gaps between the subjects might be different. Like I think in last October exam, we had only 2 days for law of persons. But before that, I can't remember what the subject was. We had like a gap of 5 days maybe. So obviously 2 days is not enough for law of persons because like there are several areas, right? Personal laws and other maintenance, custody, legitimacy, there are so many things to memorize. අන්න ඒ වගේ වෙලාවකදී අර කලින් තියෙන gap එකෙන් time එකක් allocate කරන්න අර අඩුවෙන් gap එකක් තියෙන subject එකකට. ඒ වගේ methods use කරන්න පුළුවන්. ඒ වගේම දැන් එක month එකයිනේ තියෙන්නේ. You will get the timetable soon. I'm not sure whether it has already been released or not. When you get the timetable, make your own timetable on how you are going to allocate the time for the 8 subjects within this month. ඒ timetable එකත් එක්ක tally වෙන විදිහට තමන්ට timetable එකක් හදාගන්න බලන්න. ඊළඟට වැදගත්ම දේ තමයි මෙන්න මේ lastම point එක. ගොඩක් අය අහන දෙයක් තමයි අර full blown answers memorize කරගත්තොත් පුළුවන් මේ පාස් වෙන්න පුළුවන්ද කියන එක. It might work. But what I think is it won't help you to get a good mark. You will be able to pass the exam, but the examiner will know that you are just parroting out a pre-prepared answer. ඒ නිසා අර දීලා තියෙන question එක address වෙන විදිහටයි අපි answer එක build up කරගන්න ඕනේ. ඒක නිසා answer එකක් කටපාඩම් කරගත්තොත් හිතන්න වෙන විදිහකට මේ ක්වෙස්චන් එක ඇහුවොත් එතනදී Taman කන්ෆියුස් වෙනවා. ඊට පස්සේ මුකුත් ලියාගන්න බැරි වෙනවා. ඒක හින්දා හරියට ලෝ එක දැනගෙන යන්න. එතකොට එන ඕන ක්වෙස්චන් එකට ලියන්න පුළුවන්. ඒ නිසා ආන්සර්ස් කටපාඩම් කරන එක මම ඒක රෙකමන්ඩ් කරන්නේ නැහැ ඇත්තටම. And if you have any questions, you can put them into the chat box. So the next important thing is choosing questions and structuring answers. So like many people are asking what they should select. What are the areas that they have to study? එතකොට ස්කිප් කරන්න එපා දැන් පාඩම් කරන කාලේ මේ කියන්නේ පුළුවන් නම් හැම ඒරියාවකම පාඩම් කරන්න අර වෙන ඔප්ෂන් එකක් නැත්නම් විතරක් ස්කිප් කරන්න කියන එක තමයි මම කියන්නේ. මොකද when you are skipping areas it will be risky. මොකද there could be a chance of getting a question with several areas combined together. එතකොට question එකෙන් භාගයක් විතර answer කරගන්න බැරි වෙන්න පුළුවන්. ඒක නිසා make sure that you are giving your fullest effort to study all areas of every subject. So I'm planning to go by subject from subject. Right. So criminal law. criminal law ගැන කියනවා නම් ඒක ගොඩක් අය ස්ට්‍රෙස් වෙනවා criminal law වලට. මොකද content එක වැඩි වෙන්න පුළුවන් and this is the whole syllabus. And our lecturer, Janaka sir, there is this thing that he always says, if I have completed the syllabus, I remain the right to formulate a question from anywhere I want. ඒක සර් නිතර කියන දෙයක්. ඉතින් ඒක ඇත්තනේ නේද? සර් සිලබස් එක කරන්න සර්ට පුළුවන් ඕන ඒරියාවකින් question එකක් අහන්න. හැබැයි මේ ඔක්කොම ස්ටඩි කරන එක overwhelming වෙන්න පුළුවන්. ඒ නිසා what you can do is go through the past papers and analyze how the questions have been formulated. I did it for the last two papers, just as an example. So, here, April 2025 and October 2025, these two papers have like a common pattern. I can see a common pattern. So when we go through this, you can see that the first question is on culpable homicide or murder, basically murder, the compulsory question. So I can't say for sure that that will be the same this time, but if you go through the past papers, it seems like there is this tendency to formulate the first question on murder. Then general exceptions. General exceptions is once again a huge area. ඒක අනිවාර්යෙන්ම question කරන area එකක්. Make sure that you are going through it. So we have some questions. Yes, someone is asking where we can find Sinhala lecture notes. Sinhala lecture notes මෙහෙමයි කියන්නේ classes වලින් එහෙම notes ළමයි ගන්නවා හොයා ගන්නවා. ඒ විදිහට තමයි මම දන්න විදිහට සිංහල lecture notes හොයාගන්නේ එහෙම තමයි. classes වලින් තමයි සිංහල lecture notes හොයාගන්නේ. නැත්නම් translate කරගන්න පුළුවන්. ඒත් translate කරොත් ඒක ප්‍රශ්න වෙන්නේ අර ඔරිජිනල් මීනින් එක වෙනස් වෙන්න පුළුවන් යන්න හිම ඉෂුව එකක් තියෙනවා. ඒ නිසා ඒ වගේ අර හරියට බලන්න ඕනේ මේ ට්‍රාන්ස්ලේෂන් එක ඔරිජිනල් නෝට් එකත් එක්ක ඔරිජිනල් කන්ටෙන්ට් එකත් එක්ක ටැලි වෙනවද කියලා. ඒ නිසා බලන්න එහෙම මේ හරියට හොඳටම තියෙන තැනකින් මේ නෝට් එක හොයාගන්න බලන්න. ඊළඟට තව question එකක් තියෙනවා. Is it enough to focus on topics that are discussed in law college revision classes? The thing is, some lecturers discuss some selected topics. But the lecturers, like let's say our constitutional law lecturer, he discusses everything in the revision. And Janaka Bandara sir, he discusses all topics. So you can't say that you can't pick and choose those topics. There are some lecturers who discusses like some selected areas, but I can't say like it's risky. It's risky if you are going to limit yourself to only those topics. ඒ නිසා කියන්නේ වෙන ඔප්ෂන් එකක් නැත්තම් විතරක් එහෙම කරන්න. ඒ වුණාට අර අනිත් ඒරියාසුත් බලන්න. ඒක මොකද නැත්තම් ඒක රිස්කි. අර මං කලින් කියනා වගේ ඒරියාස් දෙකක් කම්බයින් වුණොත් ක්වෙස්චන් එකෙන් භාගයක් විතර ලියන්න වෙන්නේ. ඒ නිසා ඒක බලන්න. right. Uh, as I was saying, general exceptions, you can't leave it. එක හරිම important area එකක්. ඒ වගේම ඒක study කරනකොට general exceptions වල you can see some illustrations. Illustrations තියෙනවා ඒ sections වලට, and there is a very good chance for you to get a question based on those illustrations. If you go through the past papers, you can see some examples. ඒ නිසා illustrations බලලා ඒවට ෆැමිලියර් වෙන්න. එතකොට අර සෙක්ෂන් එකෙන් දෙන ඒ මීනින් එකත් ඔළුවට යනවා. ඒ වගේම එක්සෑම් එකටත් ඒක හෙල්ප් එකක් වෙනවා. And then vicarious liability. Vicarious liability, the thing is you can get a standalone question. Uh, the issue is it's broad. Like there are several subtopics under vicarious liability and many sections, like for abatement, it's very descriptive. So like let's say that you don't have time to go through everything, and if you're planning to leave this question, let's say that you are planning to leave it, but make sure that you have at least some sort of an idea about what is meant by these things. Because let's say there is a vicarious liability part in this compulsory question, then you won't be able to get the marks for that part. ඒක නිසා අර මේ සම්පූර්ණයෙන්ම අතාරින්න එපා ඒරියා එකක්. අයිඩියා එකක් හරි තියාගෙන යන්න වෙනවා. Then I'll leave kidnapping and abduction for a while. Property offenses. If you go through this, see, offenses against property. This is a huge area of your syllabus. So you can't leave it at all. With theft, extortion, robbery, criminal misappropriation, and criminal breach of trust, those areas are very important. That I don't mean that you won't get questions from the areas like forgery and trespass, but මේ areas ටික නම් අතාරින්න බෑ. මොකද ඒවයින් questions එනවාමයි. And last time we even got a question from cheating. cheating කියන area එක serve lectures වලදී ගොඩක්ම emphasize කරපු area එකක්. ඒක I think I can remember he said that this is a good area to formulate a question. එහෙම sir කිව්වා. Lectures වලදී. And that Kapila Nishanka case and those four limbs developed by the court, ඒ දේවල් sir descriptively discuss කරා class එකේදී. ඒ නිසා ඒවා අතාරින්න එපා. Even if you are planning to leave these areas like trespass and forgery, never think about leaving these topics: theft, extortion, robbery, criminal misappropriation, CBT, those things. Because the other thing is, there is a chance for you to get questions like based on comparisons, like compare theft and extortion, or like robbery and CBT and criminal misappropriations. So if you go through sir's notes, you can see that he has allocated a huge number of slides just for comparisons. ඒක නිසා there is a high chance that you will get that sort of questions. ඒ නිසා ඒකයි කියන්නේ අර අතාරින්න එපා. questions areas combine කරොත් එතන risk එකක් තියෙනවා. හරිද? එතකොට if you go through the last year paper, last October paper, you can see that there were 3 questions on property offenses. So as I remember, I think I did all 3 questions on property offenses. Criminal misappropriation, cheating, and this one, theft, robbery. So that means half of the paper is done. And you have only 3 questions remaining to do. එතකොට බලන්න property offenses හරියට study කරොත් paper එකෙන් ලොකු portion එකක් කරගන්න පුළුවන්. ඒ වගේම sexual offenses. Sexual offenses, that is a definite question. If you go through the past papers, you can find a question on sexual offenses. But don't limit your studies only for rape. you can get questions from other areas like sexual harassment and grave sexual abuse, and maybe you can be asked to like compare between them. ඒ නිසා ඒ හැම area එකක්ම බලන්න වෙනවා. And hurt, once again, that is a small area. It's easier to study. ඒක කරන්න පුළුවන්. Doable area එකක්. And then these acts. So during the lectures, as I remember, sir discussed 3 acts. And during our revision for October paper, he emphasized this Computer Crimes Act, and we got a problem question on that. So I think Janaka sir hasn't done revision for criminal yet. Maybe he'll be doing it next week. I don't know. Anyway, Computer Crimes Act is a good area. It's easy. Like there are no case laws, and it's just an act. There are some sections for you to remember, and it's not hard. It's just common sense. It's not hard. ඒ වගේම ඒකේ vicarious liability part එකක් තියෙනවා Computer Crimes Act එකේ. There are these statutory provisions are allocated for that vicarious liability part as well. And in your question, there will be a part on that. If you go through the last October paper, you can find that. එතකොට බලන්න දැන් මේ analysis එක දිහා බැලුවාම doable questions 6ක් තෝරගන්න එක අමාරු නෑ නේද? දැන් property offences හරියට පාඩම් කරන කෙනෙක්ට at least questions 2ක් කරන්න පුළුවන්. ඒ වගේම murder කියන area එක ඉතින් there cannot be a criminal law paper without a question on murder. So you have to study it. අනිත් ඒවත් එහෙම අමාරු නැහැ study කරන්න. Main දේ තමා when you are studying criminal law, make sure that you are going through the sections in penal code very well. And there is another thing that sir emphasizes, that you can't study the section as it is. You have to break it into small pieces. ඒක අර ඒ විදිහටම කරන්න අමාරුයි ඇත්තටම. Even at the exam, there is this thing I did. Like it's hard to write the section in one sentence. It's hard to uh, align the ideas properly. When that's the case, what I did was I just mentioned like this. In section 293 of the Penal Code, for an offense to be a culpable homicide, the following requirements should be met, like that. And then I listed down the requirements. So it's easy. I mean, other than like, it's hard to write the section in one sentence. That's a tip that you can follow. Right. And once again, as I explained before, explanations and illustrations are very important. Make sure that you are incorporating at least one illustration in your answer. Like for criminal misappropriation, I think there are so many illustrations. So you can get a question based on an illustration. Illustration එකට සමාන scenario එකක් දීලා question එකක් අහන්න පුළුවන්. එතකොට if you are very familiar with those illustrations, if you have read it before, then it's very easy. එතකොට මේ තමයි criminal law ගැන කතා කරන්න තියෙන්නේ. Questions තියෙනවා නම් chat box එකට දාන්න. මේ අමාරු subject එකක් නෙමෙයි criminal law කියන්නේ ඇත්තටම. It's very interesting if you study it properly. Right? Then let's talk about law of persons. So in law of persons, you have part 1 and part 2. So for part 1, you have 8 questions and you have to answer 4 out of 8. The first question is the compulsory one, and if you go through the past papers, you can see that it is mostly based on dissolution of marriage, right? Divorce and all. I mean, we can't say it for sure that it will be the same this time, but if you go through the past papers, you can get that hint. And then for the rest of part 1, you will get questions on maintenance, adoption, other parts that are done by Shehan sir, our deputy principal sir. And then you can get questions on like breach of marriage promises, irretrievable breakdown of marriages, which are done by Ilyas. And then you can get short note question also. And the other one is succession. So for law of persons, I have to say that it's a very good subject for you to get your average up. But this time as in last October, I think the marks were a bit lower than the last years. But I think this is a good subject. It's not hard. If you study, it's not hard. And another thing that I wanted to tell about law of persons is uh, I selected problem questions. All questions that I did for this paper was problem questions. I did the compulsory one, compulsory question on dissolution of marriage. And then from Shahansa's questions, I selected two problem questions. And then I did this succession one. I did not do the short note questions because I believe that that's my personal opinion. When you do problem questions, uh, the chance is less for you to miss any points. But when you are doing an essay question, you have to have a very good structure. But for problem questions, if you follow the IRAC method, there is this order, right? There is this order, and I don't know when I am answering problem questions, I feel confident. That's why I selected problem questions only. But for the subjects like constitutional law, obviously you have to do essay questions. But for this, that's the method I followed. And some people do not do this succession part, but it's very easy. I have to say that if you have attended the lectures and if you have gone through the notes at least twice, it's not hard. It's interesting. Succession part is interesting, and I guess Madam has already done the revision. If you went to the revision, you might already know that she does not expect a very lengthy answer. She wants your answers to the point. ඒ ක්වෙස්චන් එකට ආන්සර් එක ලිව්වොත් ඒ කියන්නේ එක්සෑම් එකේදී මම ලියපු ආන්සර් එක මට මතක විදිහට එක පේජ් එක සයිඩ්ස් දෙකක් වගේ තිබුණේ. ඒ කියන්නේ වැඩිය ලියන්න ඕනෙත් නැහැ. ලියන්න ඕනේ නැහැ කියන්නේ ඒ අවශ්‍ය පොයින්ට්ස් ටික ලියවුවාම පැති දෙකකට වඩා ගියේ නැහැ මට. The other thing is, if you can do this succession question, you can save a lot of time because the questions like maintenance consumes a lot of time because there could be like several parties. You have to advise the spouse and children, adult offspring. There are so many parties, and you have to advise each of them. There, you have to spend a lot of time. So you can save some time for those questions by attempting the questions like succession. I'm not recommending you to do succession if you haven't like gone through the notes or if you haven't attended the lectures. If you can do it. But like if you don't know anything about it, don't attempt it because then it will be hard. But if you know something about it, that is a good area. And then for part two, personal laws, I did Muslim law questions, the two questions from Muslim law. The thing is, for this part, it's good to master one personal law other than just skimming through all three. කැනෙ තුනම පොඩ්ඩක් නිකන් යන්තම් බලනවට වඩා එක ඒරියා එකක් පර්ෆෙක්ට්ලි බලනවා නම් ඒක හොඳයි කියලායි මම හිතන්නේ. මොකද දැන් පොඩ්ඩක් බලලා එහෙම ආන්සර් එකක් පර්ෆෙක්ට්ලි ලියන්න බෑනේ. එතකොට එක ඒරියා එකක් හොඳටම බලනවා නම් Tamanට confident වෙන level එකට බලන්න පුළුවන් නම් then you can answer whatever question they are asking. That's what I did. If you prefer Teswala law, that's all right. Then you can do it, and Candian law. But it's good if you can have a backup. Like I prepared for Muslim law, but I went through Tesawalame law notes and just like I kept it as a backup. But anyway, I did Muslim law questions. That's about law of persons. It's not hard. You have to read the question properly. I'll give you an example later because the people who did the last October exam misinterpreted a question and wrote something else. I'll show you that example later. Right. And then legal history and legal system. People are so stressed about this subject, and this is like, it's not hard. The thing is, you can't predict what will be there for the compulsory area. Because if you go through the last few papers, the first question was based on sub-legal system. Like, I think last April paper and before that, it was about the sub-legal system. But in last October, it was on common law. So you can't say for sure that it will be on this area, right? So that's what I'm telling you. You can't leave any core areas because common law is a very, like, it's a very descriptive topic, and Father Noel Dias described, like, he spent a lot of time on it during the lectures. ඒක නිසා ඒ වගේ core areas අතාරින්න එපා. මොකද ඒක රිස්කි. ඒ නිසා එහෙම අතාරින්න යන්න එපා. ඒ වගේම දැන් මේ reception of English law, then present court system, Dutch court system, Dutch administration, these areas, they are like definite questions. Reception of English law, you can't leave it. There will be a question for sure. Present court system, we don't know what the question will be based on. Like maybe it's on Supreme Court or Court of Appeal. We can't say for sure, but there will be a question on this area anyway. And then Dutch court system, it is like it's like you can see it in every paper. And Dutch administration. Sometimes these areas can be combined together, and you can get a single question. And judicial precedent, once again, a definite question. Roman law, a definite question. The only issue is it's very broad, and there are many subparts, and the question will be based on one of those subparts, one or two. So we can't say it for sure. And then personal laws, sometimes you will get main questions from personal laws, main like a one standalone question. Sometimes like short note questions. And customs, that is also definite area. දැන් මේ areas, දැන් personal laws වගේ එකක්, Canadian law තියෙනවා, තේසවලාමේ law, Muslim laws. එතකොට ඒ laws වල sources and applicability study කරද්දී එතන ලොකු wide area එකක් තියෙනවා. එතකොට කෙනෙක් මේ area එක සම්පූර්ණයෙන්ම අතෑරියොත් දැන් in case බලන්න last October paper එකේ Canadian law වලින් question එකක් තිබුණා වෙනමම single question එකක්, and then there was a question on I think තේසවලාමේ law. ඒතර questions දෙකක් කෙලින්ම අයින් කරන්න වෙනවා මේ personal laws බැලුවේ නැති වුණොත්. If you are leaving areas like that, then you have to make sure that you are prepared for all the other areas. ඒ නිසා ඒ වගේ risk එකක් ගන්න බෑ. අතාරිනවා නම් like judicial precedent, Roman law වගේ එහෙම standalone questions තියෙනවා. I think ඒවා එහෙම අතාරිනවා. හැබැයි but you know that judicial precedent is a definite question. එතකොට ඒ වගේ දෙයක් leave කරන එක අපරාධයි. ඒ නිසා for legal history, my advice is don't leave anything. පුළුවන් තරම් ඔක්කොම areas බලනවා නම් බලාගෙන යන්න. මොකද compulsory area එකට we don't know what will be there. ඒ නිසා අතාරින්න එපා. This is an easy subject. If you study it properly, once again, just like law of persons, you can use this subject to get your average up. It's not hard. The only thing is, I think people leave many areas. They don't study. That's the thing. It's not hard. So that's about legal history. And then law of obligations one, contract law. I think this time in October paper, October exam, law of obligations one had a very good pass percentage, I think. The thing is, our lecturer, Mr. Chamat Jayasekara, there is this thing that he always states during the lectures. He wants you to think practically. I guess he had already done the revision. Please follow the revision well. You can get a very good understanding on like what he expects at the exam. And he does not like lengthy paragraphs. You have to like your answer should be very clear with the good handwriting, and don't write lengthy paragraph. And he wants you to argue properly with applying the case laws. Sir කියන්නේ අර මේ කියන දෙයක් තමයි මේ exam එක, it's not an educational qualification කියන එක. මේක ඒ කියන්නේ professional qualification එකක් කියන එක. ඒ නිසා sir කියනවා LLB answers ලියන්න එපා කියලා මේ subject එකට. ඒ නිසා make sure that you are writing to the point. Law of obligations is not hard. It's very interesting. It's not hard. Revision එක follow කරන්න. ඒ සර්ගේ notes වල තියෙන case lawsම ඒවම ලියන්න, අනවශ්‍ය case laws ලියන්න එපා. ඒ note එක හරියට study කරන්න. I think you can get a very good mark. Law of obligations. And then constitutional law. Once again, this is also a subject for you to get your average up. And once again, as Suren sir always says, not to rely on old recycled notes. He always says that he wants you to follow his lecture notes because like he has like an updated set of case laws. You have to read them as in, obviously now you don't have time to go through all those judgments. At least go through the statements that sir has extracted and pointed out in the lecture note. So you have to go through sir's notes. And fundamental rights, I want to mention this fundamental rights part is very important. I think sir spent so many weeks only for that part during the lectures. And even if you see the last two papers, April 2025 and October 25 paper, they are the papers made by Sorensa. You can see that there were like 3 questions from fundamental rights. So that means half of the paper is done if you are well prepared for fundamental rights part. So that's very important. You can't leave it because the compulsory question is also most of the time it's based on fundamental rights. So make sure you are well prepared for that. And I'll leave conflict of laws for the end because since some of you are not doing it. Then industrial law. Industrial law, once again, it's not hard, but make sure that you are following sir's notes, Professor Alwis's notes. And තව දෙයක් තමයි සර් කියනවා සර්ගේ ඒ කියන්නේ lecture notes වලත් සර් දැන් අවුරුදු කීපයක් law college එකේ teach කරනවානේ. ඒතර සර්ගේ notes වලත් අර most recent updated notes ම follow කරන්න. මොකද සර් case laws අලුත් case laws දානවා, judgments mention කරනවා. ඒ වගේම සර්ගේ articles, research papers වල references දානවා. අන්න ඒ නිසා අර updated notes ම follow කරන්න පරණ notes නැතුව. ඒ වගේම make sure that you are following sir's revision well. And then about the IRAC method. Sir does not mention specifically about IRAC method, but if you want, you can follow it. Like I followed IRAC method when answering industrial law questions because it's easy. It's easy to formulate your answer. And another thing is, sir does not expect the full case name. You can just write one party, so that's good. And this is just an outline on how the questions were formulated in the last October 2025 paper. So like if you go through the last few papers, you can see like this was the pattern. The questions that are in part 2 are like right to strike, workman's compensation ordinance, gratuity. If you go through the papers, you can see that pattern, but we can't say for sure. And for the compulsory question, it could be on Teva, and IDA. We can't say that. So you have to be prepared for this. And industrial law, once again, it's not hard. My, I think, highest mark was for industrial law. I had 88. It's not hard. Just follow sir's notes. That's more than enough. And then legislative drafting and statutory interpretation, I think that subject is very easy. Uh, so for the compulsory question, half of the question will be on drafting and the other part will be on interpretation. And uh, like once again, you have to follow the lecturer's notes. And another thing for drafting, for the questions like questions on long title and short title, you need to make sure that you know properly on how to draft those long titles and short titles, because I think it's easy to get marks, but if you make any mistakes, you will get 0 marks. I think that's what sir had mentioned in the revision also. So you make sure that you know it properly. If you don't know, don't attempt it. Uh, but I think since you have 1 month, you can go through the notes and find out what's the exact way to how to draft a long title and a short title. So like that. And then now I'll go to conflict of laws. Mabroor, there are these two red lines. Can you erase it?
Yes, sure. Let's try.
Okay. Okay. Now conflict of laws. Conflict of laws is it's like now you have already applied for the exam now, so some of you might be doing environmental law, but I will just uh, describe this briefly. So here you have two compulsory questions. That is the difference with when it is compared with other subjects. You have two compulsory questions, and the question number one, it is just like you have to mention whether the statements are true or false, and 20 marks allocated for that. And for you to do that, you need to have an overall understanding on the whole syllabus. Like you won't be a question on like what happened in this case and all. You have to know the theories very well. It's not hard. And if you go through the past papers several times, you can see the pattern of questions. So it's easier to score and it saves time. That's the most important thing. It just takes like 10 minutes, so maximum 15 minutes to for you to do the question number one. So it's good. It's a plus point. And then question number two, don't think that it will be entirely based on domicile, because last October paper in the if you go through it, you can see that there is this part on conflict of laws with related to law of property also. So law of property part, that is done by Miss Bari. Domicile part is done by Miss Dilomidi Alwis. So you can't just like leave any areas. That's what I'm telling you. And also you can get standalone questions from the areas like law of conflict, uh, conflict of laws in law of property and law of tort, then family law, like that. You can get separate questions as well. And in question number three of last year October paper, you can see that it's like a combination of many areas. There was it was like a question with subparts. I think there were three subparts. You need to have an idea of many areas. So that's what I'm telling you again. Don't leave anything. And conflict of laws is once again a very good subject for you to get your average up. If you go through the results sheet, I think you can see students have scored very good marks for this subject. So nothing stress about. Right. Mm. Right. Now let's look at some of the general guidelines you can use and they'll ask from where they should start answering the question. Question number 1 එකෙන් පටන් ගන්නද එහෙම නැත්නම් question number 1 අන්තිමට තියාගන්නද එහෙම අහනවා. My advice is keep it as your maybe third or fourth answer. Don't start writing the paper, writing your answer script with question number 1, because I think like it takes time, because sometimes there are several subparts, like in the paper law of constitutional law paper there are several parts, and the other thing is අන්තිම එක විදිහට තියාගන්න එපා, because I made mistake for constitutional law an hour and I did not have that much time now, and I couldn't write it the way I expected. In the fourth or fifth option එක හරි නැත්නම් third fourth අන්න ඒ වගේ තැනක මේ third හරි fourth හරි option එක විදිහට first question එක answer කරොත් හොඳයි කියලා තමයි මට හිතෙන්නේ. And the other thing is you have to read the question properly. This is an example. This is from Law of Obligations 1, 2025 October. So here you have to look at these operative lines and like to whom you should advise. Here it's asking Mr. Desmond now seeks your legal advice. Make sure that you read the question properly. It doesn't matter that you have to spend 2-3 minutes to read the whole question. That's all right. හරියටම බලලා කාටද ඇඩ්වයිස් කරන්නේ මොන පාටි එකටද කියන එක හරියටම බලන්න. බලලා ආන්සර් එක ලියන්න ගන්න. මොකද මම අර කලින් කිව්වා නේද එක්සැම්පල් එකක් පෙන්නන්නම් කියලා අර law of persons වල සමහරට marks අඩු වෙන්නේ නැත්තේ මෙන්න මේ reason එක නිසා වෙන්න ඇති. Here this is question number 1, law of persons. Here it says Ishara seeks your advice on her position and potential legal liability. So here Ishara is not the wife. She is the person who was having an affair with the husband. So you have to advise that person, that woman. Ishara. So I think many people had advised the wife. Isa, then the analysis part will become very different when you're advising another party. And I think a lot of marks are allocated for the analysis part. එතකොට marks අඩු වෙන එක හරි. ඉතින් එතකොට marks අඩු වෙනවා. And Isa, make sure that you read the question properly. Right? So you can just underline if you want. Underline the keywords and operative lines to make sure that you are paying attention very well. And here, this is from Legal History and Legal Systems paper. Question number 1. In course of time, Roman Dutch law has been subject to progressive development by courts on procedure, as the courts of Ceylon have applied its basic principles to the solution of legal problems posed by changing conditions of society of Ceylon. And the case is Studena versus Attorney General. This statement is from this case. And here, this says critically analyze the above statement, citing some instances where the Sri Lanka a vibrant entity rather than relegating it to archives. එතකොට මේ vibrant entity කියන word එක ඇත්තටම ඒකෙන් mislead වෙලා තිබුණා ගොඩක් අය. මේ question එක sublegal systems වලින් අහපු එකක් කියලා sublegal systems ගැන ලියලා තිබුණා. එතකොට you have to master the skill of identifying the keywords of the question. දැන් මෙතන කියනවා Roman Dutch law ගැන. ඒ වගේම development by courts on procedure. ඒ කියන්නේ අර ශ්‍රී ලංකන් කෝට් එක Roman Dutch law එක ඒ විදිහටම apply කරනවා නෙවෙයි. කෝට් එකෙන් develop කරගෙන වෙනමම distinct unique legal system එකක් develop කරගෙන තියනවා කියන idea එකනේ තියෙන්නේ. එතන මේක it's a basic concept that was discussed under the topic of common law. මේ Cordiswaran versus Attorney General කියන case එකත් specifically mention කරපු එකක්. එතකොට common law කියන්නේ it's a core topic in legal history. So that's what I'm telling you. You can't leave those core topics. You have to make sure that you are paying attention to every topic. එතකොට මේ වගේ words වලින් මේ mislead වෙන එක අපරාධේ. ඒ නිසා once again I'm telling you, make sure that you are paying very good attention to the keywords. Underline them if you want and try to understand what they are asking. You have to address the issues raised by the keywords of the question. ඒ වගේම තව කරන්න this from my paper. Right. When you are reading the question, you can just make a small sketch. You can underline them, and when you're reading, you can make a small sketch, because otherwise, let's say that when you're writing the answer, you suddenly forget something and you can't remember what happened after this. And then you have to refer to the question again. You have to read everything by one. If you made this, you can just have a look and spot the issue that you want to address. ඒක නිසා මේ විදිහට අර එක එක හදාගන්න එක. එතකොට ඒක refer කරන්න ලේසි. And this is for succession, a structure that I made for succession. So like when you make sketches like that, you can get a very good visual understanding and visual understanding on the question. එතකොට අර මේ ආය paragraph එක අස්සේ තියෙන මේ words කියව කියව ඉන්න අවශ්‍ය වෙන්නේ නැහැ. And this is for constitutional law. Here you can see that from the beginning, I have just mentioned the area of the question, the side of the question, left side. So like rule of law and fundamental rights, 13th Amendment, public trust doctrine. So when you write the areas, then you can just pick it out. Okay, I'm going to write this one and this one. Okay, and then IRAC method. So IRAC method, I think like it's very easier if you can follow it, because as I mentioned before, if you follow it, the chance to miss any points is very less. And I plan to discuss this answer. Answer as in I'm not to discuss a full-blown answer. I'm just trying to give some guidelines on how to make the structure for a question like this. This is criminal law paper, October paper 2025, question number 1. So this scenario was discussed during the revision as in revision for October exams. So discussed this case, and the question was also based on that. And here, I guess that you're familiar with question. So here they are asking, we have to discuss with reference to the offense of murder, relevant special exceptions, and the distinction between culpable homicide amounting to murder and culpable homicide not amounting to murder. And you have to support your answers with legal provisions and case laws. So, and I have a question. How to remember cases and section? Any method? Repeated reading. Should read all cases. Yeah, repeated reading as in, if you want, you can make some sketches. Sketches as in just uh, sketches that will be easier for you to remember the important points of the section. ඒ කියන්නේ නිකන් වෙනම sheet එකක you could just mention section 293 or section 294 and you can just draw some diagrams like that. Any method that is easier for you, that works for you. Rereading is good, but the thing is, penal code, just reading the penal code as it is won't help you to understand the material. මොකද penal code එකේ තියෙන්නේ අර section එක නිකන් අර words අර paragraphs chunks වගේනේ. ඒකෙන් අර memory එකට යන්නේ නෑ ඒ විදිහටම. ඒ නිසා ඒක පොඩි parts වලට break කරගන්න. break කරලා study කරන්න. ඒ විදිහට තමයි මම කරේ. එහෙම නැතුව ඒ විදිහටම පාඩම් කරන්න අමාරුයි ඇත්තටම. criminal law වල. Right. Okay, so here, this question, this is the structure that I followed when I was answering this question. So here, the issue is whether Duminder's defense counsel will be successful in reducing Duminder's charge to culpable homicide not amounting to murder. එතකොට එයා murder වලට තමයි යාව indict කරලා තියෙන්නේ. ඒක culpable homicide not amounting to murder වලට reduce කරන්න තමයි දුමින්දගේ counsel හදන්නේ. අපි ඒකට agree වෙනවද කියලානේ අහන්නේ. එතකොට murder questions වලදී anyway you have to start with section 293 of the penal code. ඒක definitely mention කරන්න ඕනේ. 293 explain කරලා ඒ points list down කරන්නම ඕනේ. 294 වලින් කෙලින්ම start කරන්නේ නැහැ. 293 mention කරන්න ඕනේ අනිවාර්යෙන්. Then you can say, then you can mention section 294 where culpable homicide will amount to murder. Then you can mention 4 limbs. 4 limbs where culpable homicide would amount to murder. එතකොට ඒ limbs ටික කියන්නේ මේ scenario එකට applicable when all 4 limbs. Then what you can do is pick the most relevant limb for the given scenario and then explain it descriptively, right? Then you can like with case laws and the applicable illustration. එක එක limb එකට illustrations තියෙනවනේ penal code එකේ. ඒ illustration එක දාලා explain කරන්න ඒ අදාළ limb එක. ඒ වගේම case laws. Case laws applicable for that particular limb. හැම case law එකක්ම හැම limb එකටම අදාළ case laws නෙමෙයි. ඒ limb එකටම අදාළ case law එකක් අරගෙන ඒක describe කරන්න. Describe කරන්න කියන්නේ you don't have to write everything that happened in the case. You can just summarize it in like let's say 3-4 lines. Summarize it. Make sure that you so it's decided in this case, okay, this is applicable to the given scenario in this way. ඒ විදිහට apply කරන්න. හැමතිස්සෙම relate කරන්න. අර නිකම්ම note එක ලියන්නේ නැතිව you have to relate to the given question. Right? And then chain of causation. Chain of causation mention කරන්න case laws එක්ක chain එක මෙතන break වෙලාද නැද්ද break වෙලා නැත්නම් ඇයි අන්න ඒ දේවල් ලියන්න වෙනවා. Right? ඒක කියන්න ඕන application part එකේදී. Then what you can do is application. Oh, I just mentioned about application here as well, but it was just for the explanation purpose. You have to do the application now. And then what you can do is apply the law that we discussed here to the given scenario. And then state, okay, this is why Dominder has been indicted for murder. Then you can give your conclusion. Then what we have to analyze is the defense counsel, Dominder's defense counsel states that is it a culpable homicide? So yeah, the question is asking whether we are agreeing with that. So now what you have to mention is, you can say, okay, uh, under section 294, there are these special exceptions. So you have to write all special exception like in a summarized way. Just summarize the content and then pick the special exception that is applicable to the scenario. So here I think it is grave and sudden provocation. You have to explain it properly. And maybe you can use some case laws, and you can write the illustrations or explanations or anything if there are any, and make sure you do it properly. And also the subjective and objective tests for loss of self-control. And there are case laws, and sir discussed this very like descriptively during the lectures also, so you have to mention about that. And then the law part is done, the rule part is done. Now it's about application. So now here you have to say, how was he provoked? Right? The thing is, here this person, Duminder, was a former army soldier, as I remember. Yes. Yes, Duminder was an active serviceman attached to the Sri Lanka army. And here, what we have to say is, this is an argument that Sir mentioned during the revision, that Duminder has to be judged with the people of the same class as in he was an ex-army soldier, and he is like very keen on discipline, and he want everything to be done in a proper way. So he has to be compared with that class of people. So if we compare his mental state or whatever with those sort of people, we can say that yes, he was provoked. And you can give your own arguments as well. I'm just telling you what's mentioned, and you can come up with the proper arguments as long as you can substantiate it, and then you can come to a conclusion. So you can say that, okay, this is, and additionally, you can give an argument like this. Uh, in section 291, culpable homicide amounting to murder, the punishment is 20 years. But if 20 years, if the mens rea element is intention. It is only 10 years if the mens rea is just by looking at Duminder's behavior. He has provided for a poor family. He has provided for the education of these children whom he had no blood relationship with. So looking at all these factors, we can see that it is highly unlikely that he had any intention to harm this boy. So we can say he had no intention. He did it because he lost his self-control. He might had the knowledge, but it's very unlikely that he had any intention. So you can say Dominder's defense counsel may be successful in proving the fact that he did not have the intention, but the knowledge. So his punishment will be just 10 years. Like that, I'm just telling you, you can come up with the arguments like that. So probably you will get a question like this for your compulsory question this time. So once again, anyway, you have to follow the structure. I mean, you have to start with section 293, then go for 294, the limits and the special exceptions, and any other arguments that you can make like that. So also make sure that you are relating whatever you are writing, you have to relate it to the given scenario. Don't just reiterate everything in the question and don't just write the note. You have to apply it. You have to relate it to the question, right? That's about this question. And I could have just discussed a full-blown answers, but I don't think that is beneficial because the thing is, what you have to know is the structure. Because if you know the structure, you can apply it to any question. That's the most important thing. And then about essay questions. So for essay questions, like even in the essay question, there is an issue. They are asking us something. We have to, sometimes they're asking, do you agree with this? Critically analyze it. And like that. And compare and contrast. Like that. There are still, even in the essay questions, there are issues. So you have to spot the issues. You can spot the issues by identifying the keywords of the question. Just like I mentioned before in the question I showed you here. මේ විදිහට දැන් Roman Dutch law has been subject මේ keywords තියෙනවා. ඒවා identify කරගන්න. Identify කරගෙන මෙතන තියෙන critically analyze the above statement. That is the operative line. Citing some instances where the Sri Lankan courts have responded to make Sri Lankan law a vibrant entity rather than relegating it to archives. එතකොට එතන අපිට කියන්නේ critically analyze කරන්න කියලා. Analyze කරන්න. Not just to write everything we know about common law. ඒ වගේම Sri Lankan courts කොහොමද unique legal system එකක් ලංකාවේ build up කරන්න try කරලා තියෙන්නේ. Case laws වලින් example එක දෙන්න. ඒ වගේ හැම තිස්සෙම මේ question එකට relate කරන්න. What you are writing, you have to relate it to the question. That is how you can score a good mark. And if you just parrot out whatever in your note, the examiner will definitely know that is just a pre-prepared answer or that is just a note. And he will think that you don't know what you're talking about. ඒ නිසා හැම තිස්සෙම relate කරන්න question එකට, අහන question එකට. And for the essay question, you can just have a small structure like starting with the introduction, and then you have the body, and you have to give your conclusions. Once again, don't write lengthy paragraphs. And when you're writing case laws, you can underline it and keep some space between the case law and the description that you're writing below it. And when you are listing down some points, make sure that it's easier for the examiner to see it properly. And also you have to make sure that you are writing and your handwriting is clear. It's not that you have to have perfect handwriting. Just make sure that the examiner can read it properly. Then you can give your conclusion. When you are giving the conclusion, once again, relate to the question, go back to the question, and come to your conclusion. හැමතිස්සෙම පෙන්නන්න that you know what you're talking about. Question එකට relate කරන එක තමයි ඒකට තියෙන හොඳම tactic එක. And then number of pages. ගොඩක් අය අහන දෙයක් තමයි එක answer එකක් කොච්චර දිග වෙන්න ඕනිද එහෙම. ඒතර එහෙම it's not a matter about the number of pages. ඒ කියන්නේ ලියන දේ තමයි වැදගත් වෙන්නේ. දැන් මගේ handwriting එකක් ලොකුයි. ඒ නිසා සමහර වෙලාවට pages දෙකමාරක් වගේ කියන්නේ sides පහක් වගේ 5 sides වගේ යනවා සමහර වෙලාවට. And sometimes it can be longer than that. It's all right. It's not a matter of the number of pages. It's a matter of what you are writing. The law and the application. ඒ වගේම ඒ කියන්නේ ඊට වඩා ඒ කියන්නේ පිටු 4-5 ලියන්න ඕනේ නැහැ. සමහරට පිටු දෙකකින් පැති දෙකකින් you can explain what you know about the question. එහෙම මේ පිටු ගානක් කියලා නැහැ ඇත්තටම. එහෙම අනවශ්‍ය දේවල් ගොඩක් ලියන්න එපා. And also as I know during the revision this time, once again almost all the lecturers had mentioned that not to write unnecessary things. You should write to the point. Again, this is not this is not an academic qualification. This is a professional qualification. So you need to write, like, just imagine that you are in the court. So you have to talk to the point. So that is what you should be writing in the exam as well, right? And then the number of case laws. Case laws ගානක් එහෙම කියන්නේ අර specific ගානක් කියලා නැහැ. Case laws usually I wrote about four to five case laws per question, but sometimes it can be more than that. As an example, let's say a question based on separation of powers. So for separation of powers, you have to describe how the separation of power doctrines uh, can be seen within different institutions, like between the legislative and the executive, and the executive and the judiciary, like that. You have to mention it separately. Then for each comparisons, you have to write separate case laws. So obviously, there will be many case laws at the end. ඒ නිසා අර හරියටම කියන්න බෑ මේ case laws ගානක් මෙන්න මෙච්චරක් ලියන්න ඕනි කියලා. ඒක බලන්න. ඒ කියන්නේ ගොඩක් ලියන්න අවශ්‍ය නැහැ. Whatever you are writing, once again, you have to relate it to the question. නිකන් case law එක ලියලා underline කරන එක නෙමෙයි. And තව දෙයක්. questions 6කටම answers ලියන්න ඕනිද කියන එක. ඒක time එක manage කරන්න අමාරු වෙන්න පුළුවන්. හැබැයි හොඳම දේ තමයි question 6ක්ම ලියන්න try කරන්න. මොකද questions 4ක් ලියලා එහෙම pass වෙන්න පුළුවන් ඇති. හැබැයි questions 6කටම යන්න try කරන්න. For that you have to manage your time very well. හැමතිස්සෙම දැන් කියන්නේ time එක හිතනවා නම් 30 minutes exceed වෙනවා කියලා ඒ question එක එතනින් ලියන්න එපා තව ඒක නවත්තන්න. ඒ කියන්නේ if you can just give a small conclusion, like a temporary conclusion, and you can come back and complete it again if you have time. But if you feel like, okay, I'm exceeding the time limit, don't stay there. Go to the next question. මොකද ඒ විදිහටම කරන්න මේ 30 minutes 35 40 minutes වගේ යනකොටම එතකොට අර අනිත් questions වලට allocate කරන්න තියෙන time එක ටික ටික අඩු වෙනවා. එතකොට අපරාධයි. මොකද it doesn't matter that, like, let's say you are allocating 45 minutes or 1 hour for the compulsory question. And for other questions you get only, let's say, you are spending about 20 minutes or 15 minutes. So the thing is, for compulsory question, 20 marks are allocated, right? For the other questions, just 60. Allocating 45 minutes to 1 hour. ඒක අපරාධයි. එහෙම කරන්නේ නැතුව අර පියුමල් සර් කියනවා අර compulsory question එකත් 16 marks question එකක් විදිහටම consider කරන්න කියලා. ඒක ඇත්තටම ඒක මේ හොඳ අයිඩියා එකක්. මොකද ඒකට question කියන්නේ marks 4ක difference එකකට ලොකු time එකක් allocate කරන එක අපරාධයි. ඒ නිසා ඒ time එක ගැන ගොඩක්ම හිතන්න ඕනේ. Right. So these are the things that I wanted to describe. If you have any questions, you can put them into the chat box.
Guys, if anyone have any sort of questions, you can drop it in the chat. I think Ayodya is willing to answer any of the questions which comes out.
And I have received a model answer. And I went through I received a model answer from Kasun, and I went through it a little bit now. I think the structure is okay, uh, but I think you have to mention about that subjective and objective tests, for especially since we are applying the grave and the special exception of grave and sudden provocation. You have to talk about it, and then other things are okay, I guess. Mm. And then after discussing section 293, you have directly gone to section 296. Uh, Before that, you have to describe section 294, how culpable homicide would amount to murder. You have to talk about that, the four limbs and the case laws, applicable case laws. Yeah. And to memorize the case laws and everything, case laws or sections or the ingredients in it, as I said before, make sure you are following a method that you can engage yourself, like discuss with your friends and like try to teach someone if you know it properly. So always make sure that you are not doing just passive reading. So because passive reading is not going to help you. You will get bored. Yeah. Okay, I have a question. Do you have any idea about marks allocation for cases? Actually, I am not sure about it. I guess, uh, let's say, uh, 2 to 3 marks, maybe. I'm not quite sure about that. I don't have an idea about it. Because I guess, like, the law part is very important and also the application also. Uh, so as let's say for murder question, since there are so many things to discuss, I don't think they will allocate around 4 to 5 marks just for the case laws. So I guess maximum 2 to 3 marks maybe. Yeah. And like for law of persons, when you are doing the maintenance question, it's very long. When you write an answer, just try writing an answer. It's going to be very long because there are so many parties to advise, like the spouse and child and adult, offspring and all. So then you will have to write the section again and again. But the thing is, there will be very small differences between those sections. So I guess Shehan sir might have already told you when it is almost the same you can just put inverted commas and write like use some dotted line and just mention what is different in that particular section. So that would be enough, because otherwise you will have to spend a lot of time. Yeah. And for constitutional law also, when you are explaining what is included in the article, it's hard to write it as it is, because it's obvious we can't remember everything. What you can do is just what I did was just mention the article number and say these are the specific ingredients or specific points highlighted in this article, and then you can list it down. So it will be easier for the examiner to mark also. But do it only if you are very confident about what you are writing, because if when you are listing down the points like that, it's easier to mark, and also at the same time it's easier for the examiner to spot any mistakes you have done. So make sure that you are very confident, you are sure about what you are writing, especially when you are listing down the points. And another thing I wanted to tell is for fundamental rights, uh, like definitely you will get at least 2 questions for constitutional law. It's easier if you can make a table, let's say with 2 columns, 2 or 3 columns. Column number 1, the article number and the subarticles, and then column 2, the specific ingredients in that particular article, and column number 3, the example case laws where the violation of that particular article was discussed. So if you can go through it several times before the exam, then it's easier for you to address any problem question, right? It's the If you know the law properly, you can apply it. It doesn't matter what the question is, you can apply it easily. Okay, then I have a question. Can I know about extra readings helpful to earn in marks? Yes, extra readings as in, yeah, I forgot to mention about for industrial law, especially for industrial law. Professor Sarveswaran expects us to read the articles. There are some recommended readings, some articles. Even during the lectures, he has mentioned that we have to read them. And if you can, like, if you read them and there are these specific arguments that he had made, and there are recent Supreme Court judgments mentioned in those articles, in those research papers, if you can incorporate them in your answers, I'm sure that you will get extra marks. It's good. Like as an example, industrial law compulsory question number 1, I think it was on Teva. So there was this article written by Sir, and I mentioned the arguments that he had made in this article and also the case laws. So it's important that you should go through it. Yeah. And once again, for legislative drafting, you have these PowerPoint presentations made by Selogunapalan sir. And also, other than those PowerPoint presentations, there is also this set of notes, some other notes like chapter 1, named like chapter 1, chapter 2, chapter 3. You have to go through them as well if you have to, like, if you want to formulate a proper answer. And for other subjects like conflict of laws and law of persons also, there are recommended readings, but like since we have limited time, uh, it's hard to go through everything. But specifically the things that I said, the articles written by Sarveswaran sir, you have to go through them definitely. Then I have a question. Is it important to practice 5 years past papers? It will impact negatively if I practice just 3 years papers. Uh, Negatively impact as in, the thing is, even if you can't write answers, like time yourself and write answers, just try to go through uh, past papers of 5 years. I mean, just go through it and take a mental note. Okay, these are the points that I am going to write. That will be better. If you can do more past papers, that will be a plus point. I can't say that it will negatively affect, but it's better if you can go through some past papers. කියන්නේ අර වාඩි වෙලා ලියන්න ඇත්තටම එහෙම ටයිම් එකක් නැති වෙන්න පුළුවන්. But it's better if you can just go through it. This will be better. Okay, then I have a question. Can you explain more obligation questions required method for lecturer? Yes, for law of obligations one, for contract law, sir does not expect you to write very lengthy answers. Even during the lectures, he asked us to write some answers, and he gave us feedback. The main thing that he mentioned was, this is not an LL.B exam. So he wants you to write to the point, and he likes if you make some arguments, but you have to substantiate it with the case laws. For problem questions, definitely you can follow the IRAC method: issue, rule, application, and conclusion. When there are several issues, you can start addressing the first issue, give the conclusion, and then go to the second issue. That's the mix. As I said before, even in the essay question, there is an issue that you have to address. Sometimes they will ask critically analyze and compare and contrast. Um, do you agree? Like that. So make sure you are addressing that specific issue, even in the essay questions. So, yeah. Anyway, I think almost all the lecturers want us to write to the point. That's the most important thing. You have to write it to the point. Do not write so many things like, I mean, for LL.B exams, we write the academic arguments, and like if you are studying about the UK law, we even mention about the practices of other Commonwealth countries like Australia and New Zealand and all. But here, for attorney at law examinations, we don't write those things. You have to write, just imagine that you are in the court and you have to write what you are talking at the court. Is it compulsory to write answers 2 to 3 pages for each question in all subjects? No. As long as you have written the important points, that is enough. Don't think about the length of the answers. Don't think about that, because sometimes, when I personally know, there were some students, they just write 2 sides, but they can score a lot. එහෙම සමහර වෙලාවට අර hand writing පොඩි වෙන්න පුළුවන්. ඒ වගේම අර ගොඩක් descriptively ලියන්නේ නැතුව to the point ලියලා හොඳට answers ගන්න පුළුවන්. ඒ නිසා don't think about the length of your answer. What you can do is uh, just time yourself. Just time yourself and see whether how much you can write within 30 minutes. එතකොට 30 minutes වල ලියන්න පුළුවන් ඔයාට pages 3ක්ද? ඒක කමක් නෑ. මොකද ඒ වෙලාවනේ කියන්නේ. ඒ වෙලාවේ තමන්ට ලියන්න පුළුවන් ගානේ. කමක් නෑ. But make sure you address the question properly. ඒක තමයි important දේ. Pages 5 to 6 maybe 10 pages ලියුවත් කමක් වැඩක් නැහැ. අර issue එක address කරන්න නැත්තම්. During the last revision done by Janaka sir for the October examination, he said that there was this student who had written, I can't remember the number of pages. For the question number 1, he had written maybe 20 or pages, I can't remember the number. He had written so many pages. So that's not going to help. ඒක නිසා issue එක හරියට address කරන්න ඕනේ. Then I have a question. How did you structure legal history? Yes, 36 pages. He has written 36 pages for that criminal law question. Yeah, thank you. And then, yeah, how did you structure legal history? Legal history, once again, we get essay questions anyway. We don't get problem questions. So what you can do is just identify the issue. Identify the issues, and then you can say, in the first paragraph, try to flag your answer. By flagging the answer, what I mean is just mention what the question is based on, and then you can write, okay, this is what I'm going to discuss in my answer. Then the examiner knows, okay, this student knows what he or she is writing. It's like make the first paragraph a snapshot of your whole answer. Then it's like a small summary. Then even you, let's say, you don't have that much time to come to a good conclusion. Even then, the examiner have that mentality. Okay, this student knows this. He or she didn't have enough time to come to the conclusion or write it perfectly. So that's what I'm telling you. Make sure that you write the answer in a way that you can let the examiner know that this student knows the question that he or she is writing. Yeah. And then then the body of your answer. So in the body, you can just mention the facts and the case laws, and always after writing a case law or any argument or anything, go back to the question and relate it. Okay, this is how this fact or this specific case law is related to this question. Always do that. Otherwise, it's like a note. And then if I answer with IRAC method, which part I mention case laws? Yes, for case laws are mentioned in the rule part. IRAC, issue, rule, application, and conclusion. You can mention case laws under rule R. Okay, then is Roman law an essential part for legal history and legal system? Yeah, Roman law, the thing is, you will get a question like a definite question on Roman law. I'm not sure whether it is going to be a compulsory question or not, but there will be a question. The thing is, Roman law is very broad. There are so many subtopics. So it's hard to memorize everything. If you can attend the revision and make sure you listen to it properly. So then in case, like, let's say you can get an idea on what's the most important area for the exam, you can prepare for it well. Other than, I think, going through the whole Roman law, like it's a very big area, I think. There are many subtopics. It will be hard. Yeah. Yes, the issue is that's a bit too wide. That's the thing. I mean, just like I mentioned before, attend the revision and see whether there are any, like, sir emphasizes on a specific area, then you can get ready for that. Other than that, I think getting ready for everything is not a good idea at this stage. Yeah, because there are other areas that will be definitely question. So you can get ready for those things.
Do we have any other questions to be posted? If it is a hassle for you to text, you can also unmute and ask a question. I assume there's no more questions. Okay.
We have a question, right?
Yes,
Does low
yes.
college have marking schemes available? No, I don't think so. Uh, yeah, they don't issue marking schemes, but the thing is you can get the answer structures as in some lecturers provide you with answer structures like Shehan sir give you structures the areas for the areas that he does. And I think even for law of obligations, Chamat sir has provided some structures. I think he has given a marking scheme, if I'm not mistaken. Just check your team's folders. I think there is a marking scheme. Yeah. Mm, okay.
Any more questions? Okay, I think that's a no. And I think we can conclude the session as well. Thank you so much, Ayodhya, for gracing this session and giving valuable insights for everyone who was present here today. I think not only the people who are planning to write the exam, but also I think the first years also quite a number of first year students who just started the 151st batch also joined this session, and I'm sure that they also got something out of this session throughout the proceeding. Thank you so much for gracing this occasion, and on behalf of Decode Studies, we also want to thank you again once again for being with us, spending your valuable time with us in order to help the students who are planning and hoping to write their exams very soon in April. Thank you so much. Thank you so much, Ayodhya. Okay, and thank you everyone for joining us. And we hope to see you all in the following sessions, which will be happening and which will be hosted by Pro Studies in the following weeks, upcoming weeks, which are targeting your exams in April as well. Thank you so much for attending. Thank you so much, Ayodhya, once again for gracing this service. Thank you.
Thank you, Mali, for
Have a
inviting.
good day. No worries. Thank you very much. Have a good day, everyone.